Hello and welcome to Legalese. My name is Vincent Perryman and I'm a local attorney with the law offices of J. Vincent Perryman. Each month, Legalese focuses on a wide range of legal issues and topics. Today's show covers legal contempt. With us now is Bill Jones, a local attorney with the Jones Law Firm. Bill, thanks for being with us again. And legal contempt is one of those areas that people are saying, well, what's legal contempt and how do we arrive at this?
Absolutely.
So,
well, I mean, contempt is I guess the easiest way to describe it is the court orders individuals to do something. If the mediation process or the settlement process or however you get to court, if it ends up that the judge orders the parties to perform some action or the corporation to perform some action, they're supposed to follow that edict. They're supposed to follow that ruling. And if they do not, we don't say they've disobeyed. It's not like a mother-father, child-parent relationship. They have disobeyed the court's ruling. And what they are is they're in contempt. Now, in order to be in contempt, there's a three-pronged test. Okay. And we can talk through each phase and what each one is.
Yeah, and I think we've got varying difference in contempt. We've got civil contempt and we've got criminal contempt, which actually can arise out of a civil matter versus a criminal matter. But I mean, you could have contempt in criminal court as well.
That's right. That's right. And there's a distinction between the two as to how can you get yourself out of trouble with the court. So I guess the first distinction is to qualify how do we get to contempt? Yeah. How does someone disobey the court's ruling? The first thing that we're going to ask our clients is, was there an order? That sounds pretty simple, but what I see in my family law practice quite oftentimes is an individual comes in and they're upset. My ex-wife is living with another man, or they're not allowing me to have time on this holiday. And the first thing we have to do is say, okay, well what does your order say? Because they may be upset that their ex is living with someone else, but if the order does not clearly outline that is something that can't be done, they're free to do that. So that's the first question that we have to ask is there an order that prohibits or tells them that they must perform that? The next thing that we're going to look at is, did they willfully disobey that order? So was there an order, and did they willfully disobey that? And there's some debate. That's an area where you can throw up some defense and say, I didn't willfully, I didn't, it was outside of mine, or I was negligent, I didn't know, so on and so forth. The third prong is, did they have the ability to comply with that order? And I may let you speak some on the criminal side of it, but on the civil side of it, what we're seeing a lot of is, especially in this economy, is a situation where the parties divorce and one side says, I will go and refinance my home within 60 days. Well, they go out, they try and refinance, and they can't. So there's an order saying, go refinance. A party did not, so they willfully didn't. But if they made that application to the bank and the bank turned them down, they didn't have the ability to comply with that order. So technically, they're not in contempt of court. Yeah. In your field, where do you see contempt the most?
Well, I mean, certainly when we're dealing with on the real estate stuff, we'll have people come in that they're on the back end of it and something's being foreclosed on because somebody didn't refinance this and that, and that's when we get into the whole discussion on there. And generally, when it's dealing with real estate, that's not always willful, but then you come into the question of, did you make attempts? What did you try to do to mitigate it? That sort of thing. Then the other time when we see contempt actions, generally it's going to be somebody that has just said, well, I'm just going to stop paying my support, whether it be alimony or whether it be child support, or they play that game that sometimes, I mean, when you're in that situation, you want to play that game, but you got to be the bigger person and say, you don't want to be late. You want to be within the letter of that order. So it's the whole thing of like, what I see more often is people that they're playing with what the order says. So they're kind of complying, but they're willfully saying, oh, well, yeah, I told my banker to hold up my support for 3 days. So that way I knew I'd put her in financial hardship because she wasn't letting me see my kids.
Yeah.
You know, things like that. And then a lot of times we'll see it on quadros where somebody didn't get a qualified domestic relations order done to divide up a pension plan.
Because sometimes that just doesn't get done.
Yeah.
I mean, the parties in a divorce setting are supposed to go out and somebody, and generally it's defined who it should be, is supposed to go out and have this document prepared to separate these documents. But what we're seeing is a lot of the times these people are just happy to be out of litigation. They're happy to be done with it. And whether we're talking about forgetting a quitclaim deed or a quadro, they just don't tie up the loose ends. And when they don't tie up those loose ends, that's when you and I come back into the picture, and unfortunately they have to pay a second round of attorney fees to us.
Yeah, and so many times these contempt actions arise out of just poorly drafted orders, where somebody said, okay, I'm doing this divorce, I'm getting this done or whatever for my client. They're using a form, they're not real worried about it and not detail oriented. And I mean, I understand in the industry of law you kind of get what you pay for with that, but at the same time, you as a client need to pay attention and say, okay, if I'm reading this and I'm understanding this, this says I have to refinance my home. Well, what happens if I can't refinance? When you ask that question of a good solid attorney, the answer should be, you're right, we need to put language in here that has an option of what happens when you can't refinance.
What happens when that eventuality occurs and you don't have the ability to do that?
Right, and then the other thing that I've seen time and time again with the intersection of tax law here is the IRS doesn't care what is in a divorce order as to who's supposed to pay that joint debt. And
see, yeah, and I avoided the building where tax law was taught. I didn't even go near it. But over and over again in my divorce actions, I always say this party will get the tax write-off, or the parties will split this, or they'll try and file for the year 2012 jointly. But what you're saying is it doesn't matter what I draft. If the parties don't comply with it, they're not going to be in contempt if the IRS doesn't allow it?
Well, no. If the parties don't comply with it, they'll be in contempt with the state court. But the IRS doesn't care. They're still going to take levying action against both parties because you're jointly liable for the debt. Now, you've got a contract amongst yourselves that's enforceable in divorce court that says, hey, if spouse A does not pay the joint debt for 2011, then spouse B can come back and has a remedy in this court to recoup the funds. But we're out of time for this segment, so when we return, we'll continue our discussion about legal contempt. Please stay with us.